Friends, today we had an interesting news item. This is about a PIL filed in Bangalore against Canara Bank, stating that in one of the tenders for supply of EMV cards, Canara Bank has made a provision in the tender document that the supplier should be compliant with DPDPA 2023. This has been objected to in a PIL which came before the Chief Justice N.V. Anjaria and Justice K. Arvind, and the petitioner, who was Ramaditya Tiveri, an advocate, was objecting to the fact that Canara Bank in the tender document had made reference to DPDPA 2023, which has not yet been notified for effect, whereas they should have mentioned the Information Technology Act 2000 and the corresponding requirement for protection or reasonable security practice to be practiced under the notification given in 2011 April. So the particular petition has now been actually put for hearing day after tomorrow. The interesting part of this is that the petitioner is actually fighting for a provision in the tender for protection of privacy of individuals. However, he has objected technically to the fact that reference was made to DPDPA Act, which is non-existent, versus Information Technology Act 2000. To some extent, the argument is correct in the sense that the tender should have mentioned DPDPA Act and any other law for the time being in force, because currently the law which addresses data protection is Information Technology Act, and personal data protection is covered under Section 43 capital A, and the SDPI rules of April 2011 refers to the reasonable security practices which are required to be followed and the due diligence which is required, and that is currently in force. As and when DPDPA 2023 is notified, it will replace Section 43. DPDPA is a continuation of Information Technology Act. So either Canara Bank should have mentioned that this should be in compliance with data protection laws of India and left at that, leaving it to the suppliers to actually interpret which law is applicable. Or they should have specifically mentioned Information Technology Act and DPDPA 2023, because by the time this tender is perhaps actioned, DPDPA 2023 would have been notified. So mentioning only ITA 2000 would not have been sufficient. Whereas mentioning only DPDPA 2023 also is not perhaps the correct way of describing the required law in the tender. Probably Canara Bank would agree to make necessary changes, and this case does not require any detailed discussion in the court of law. There is not much of a legal point here, except to the extent of discussing whether DPDPA 23 without the notification, but only a gazette notification on the signing of the act by the president, is it sufficient enough to consider that this act is in existence or not? That is the only legal point which can perhaps come through. And we have been always telling that DPDPA 2023 is a due diligence under Section 43 capital A of Information Technology Act as of now, and it is applicable. It is applicable not as a new act DPDPA 2023, but as due diligence under Section 43 capital A or the SDPI rules of April 2011. However, when it comes to actually putting it in the document, in the tender document, organizations should ensure some generic statements like any other data protection law as applicable in India, because we don't know, the Consumer Act may also come into being in certain cases, and IPC or the changed Bharatiya Nyaya Samhita may come into effect. So therefore, it is always better to say that any supplier should be compliant with the laws in force in general. Specifying a particular act is good, but in that case, one has to be careful that you do not leave out a law which ought to have been included. I think that is the learning which we can take out of this PIL. We can see what happens on 25th of this month, October 2024, when actually the case will come for the next hearing. Thank you.